Start. All these appeals have arisen from award/judgment and decree dated 20.5.1993, passed by Shri Nepal Singh, 5th Additional District Judge, Ghaziabad, adjudicating a number of land acquisition references, including the ones with which we are concerned in these appeals, that is, land acquisition reference numbers 2/1986, 6/1986, 153/1986, 20/1986, 7/1986, 47/1986, 154/1986, 37/1986, and 15/1986. First appeals and land acquisition references involved in the concerned appeal, as also cross objection if any, are detailed in the following chart. In these appeals, cross objection/cross appeals, in some of them there are some substitution application in order to bring legal heirs of the deceased party along with delay condonation application, as agreed by learned counsel for parties. Delay in filing substitution application, if any, is condoned, all substitution applications are allowed, Let substitution be carried out in respective appeals/cross objections/cross appeals during the course of the day, Abatement of appeal, if any, is hereby set aside, The reference court has determined market value of the acquired land for the purpose of compensation at the rate of rupees 34 per square yard, The appellant's New Okhla Industrial Development Authority, hereinafter referred as Noida, is a statutory authority, for whose benefit land in question was acquired by state of UP, A notification under section 4 (1) of Land Acquisition Act 1894 hereinafter referred as the Act 1894 was published on 5.1.1982, proposing to acquire certain land including disputed one, situated in village Gijhor, Tehsil Dadri, district Ghaziabad, The possession of acquired land was taken on 30.4.1982, The special land acquisition officer hereinafter referred as SLAO gave its award on 24.1.1985, determining market value of claimant's land for the purpose of compensation at rupees 9 per square yard, On being dissatisfied therewith, the claimant respondent along with several other tenure holders moved application for making reference to district judge under section 18 of Act 1894, pursuant whereof, the impugned award has been given, whereby the court below has determined market value for the purpose of compensation of acquired land at rupees 34 per square yard, It has also allowed 30% solatium under section 23 (2) and interest at different rates as provided under Act 1894 on the amount of compensation, Learned counsel for the appellant Noida contended that the appeal is confined to rate on which market value has been determined by court below, that is rupees 34 per square yard, He contended that the market value determined by court below is highly excessive, unjust and unreasonable, and the impugned award to that extent deserves to be set aside, full stop. Para. Per contra, Shri Madan Mohan, learned counsel for the claimants, respondent contended that the market value determined by court below is on lower side, and suggestion made by learned counsel for the appellant that it is excessive is incorrect, full stop. He, therefore, submitted that higher rate should be allowed by this court and the cross appeal / cross objection should be allowed, full stop. Para. From the rival submissions, the 2 points for determination to decide the appeal would be whether market value determined by court below at rupees 34 per square yard is just, valid and reasonable, question mark. And whether the claimant respondents are entitled for determination of market value at a rate more than rupees 34 per square yard, full stop. Para. Before dealing with the rival submission, it would be appropriate to have a glance over general legal principles which have been set in last few decades covering the question, how and in what manner market value of acquired land should be determined, full stop. Para. An award passed by land acquisition officer is like an offer and not to be treated as a judgment of trial court, full stop. It is well settled when the landholders are not agreeable to accept the offer made by land acquisition officer, they have a right to approach collector under section 18 of the Act, 1894 by a written application for referring the matter to court for determination of the amount of compensation, or if there is any dispute regarding measurement of land, for that also, full stop. In the present case, the reference in question were made at the instance of claimants for determining the amount of compensation, full stop. Para. In Chiman Lal Hargovind Das versus Special Land Acquisition Officer in bracket 1988 bracket out 3 SCC 751, the court has said that a reference is like a suit which is to be treated as an original proceeding, full stop. The claimant is in the position of a plaintiff who has to show that the price offered for his land in the award is inadequate, full stop. However, for the said purpose, the court would not consider the material relied upon by land acquisition officer in award, unless and same material is produced and proved before the court, full stop. The reference court does not sit in appeal over the award of land acquisition officer, full stop. The material used by land acquisition officer is not open to be used by the court suo motu unless such material is produced by the parties and proved independently before the reference court, full stop. Determination of market value has to be made as per market rate prevailing on the date of publication of notification under section 4 of Act, 1894, full stop. The basic principle which has to be followed by reference court for determining market value of land, as if the valuer, that is the court, is a hypothetical purchaser willing to purchase land from the open market and is prepared to pay a reasonable price as on the crucial day, that is date of publication of notification under section 4 of the Act, 1984, full stop. The willingness of vendor to sell land on reasonable price shall be presumed, full stop. The court therefore would complete market value reflected in the most comparable instance which provides the index of market value, full stop. Only genuine instances would be taken into account, full stop. Sometimes even post-notification instances may be taken into account if they are very proximate, genuine, and acquisition itself has not motivated the purchaser to pay a higher price on account of the resultant improvement in development prospects. Full stop. Proximity from the angle and from situation angle would be relevant considerations to find out most comparable instances out of the genuine instances. Full stop. From identified instances which would provide index of market value, price reflected therein may be taken as norm and thereafter to arrive at the true market value of land under acquisition. Suitable adjustment by plus and minus factors has to be made. Full stop. In other words, a balance sheet of plus and minus factors may be drawn and the relevant factors may be evaluated in terms of price variation as a prudent purchaser would do. Full stop. The market value of land under acquisition has to be deduced by loading the price reflected in the instances taken for plus factors and unloading for minus factors. Full stop. Para. Some of the illustrative examples of plus and minus factors given by the court in Chiman Lal Hargovind Das are as under. Full stop. Para. Sorry. Over.